The instant regional application is disposed of by sitting inside the input board. It is. Already trial court is directed to fix a convenient date within 2 months from the date of communication of this order, only for cross-examination of victim guard on payment of cost of rupees 5,000. Accordingly, regional application is disposed.
Oblige, Your Lordship. Oblige.
Yes. Who is in this matter? Item number 3.
Your Lordship, in this matter, Mr. Benu Kumar is appearing for the petitioner, Your Lordship. Pray for a short Passover, Your Lordship.
Pass it over.
Your Lordship, in this matter, Senior Counsel Mrs. Nag is appearing for the petitioner, Your Lordship, praying for short Passover, Your Lordship.
Pass it over.
Your Lordship, I pray for Passover, Your Lordship. Mrs. Nag is appearing for.
Where are Ms. Nag?
But I am appealing for, there are a lot of respondents. Given with the respect of. One, 4, 5, 7, 11, 13, 16 and 17.
All are not represented.
The rest of the respondents are not represented.
Directed to serve notice along with copy of upon the process party. Where is the affidavit of service?
My lord, I am praying short Passover.
Who you are for the?
Petitioner.
Where is the affidavit of service, madam? Pass it over.
Right, Your Lordship. Your Lordship, in this matter, Mr. Mir is appearing for official respondent, Your Lordship. I pray for short Passover.
Why in every matter everyone is praying for short Passover? Did I rise early? Mr. Ji. Yes, item number 7.
Your Lordship, in this matter, also
Passover.
6, I am appearing the petitioner.
From item number 3 to 7, all matters, learned advocate, junior advocates are praying for Passover.
My Lord, item number 6, I want to make one submission.
You are for the,
Petition.
who is for the office?
Same.
I see Ms. Bhavita Das is appearing for the.
Kindly see the last order, just last order. Item 6.
Yeah, for affidavit in service. The affidavit in opposition.
Yes, September 25. Now we are,
Let senior come. He is praying for Passover. Item number 7,
same, my lord.
said. Pass it over once.
As per directive, I have filed the affidavit in the registry. I am serving the copy to my sister.
My lord, I am the petitioner. My lord, daytime may be given so that I will be filing my reply.
You are for the petitioner.
I'm going to-
What is in this matter?
My lord, this is for an electricity connection, my lord. With an encroached land, a representation has been made to
Yeah.
the authority concerned,
Without
dated
reply, she is ready to argue. I am ready to argue.
38/20.
If she wants to file reply, let her file.
My
reply
lord, it's a small
thereafter.
matter, my lord, because.
Yes, I know it is, for everyone it is a small, but for me it is very difficult.
Opposition I have not read, my lord. So I need actually to read this opposition and if it is
Very well.
necessary, I'll be filing the reply or.
Learned, on the prayer of learned advocate for the petitioner. Let this matter appear before the next circuit bench. In the meantime, she is directed to file affidavit in reply, if any. Let the matter appear before.
Obliged. Next to next.
I appear for the petition in this matter, your lordship.
I am appearing for the respondent from municipal council. Has been received many facts, but required affidavit opposition.
I think this requires an affidavit, your lordship, because
Because we have to.
they have to justify
You are for the,
TDMC.
Port Blair Municipal Council. Sir, Rakesh sir,
What to-
शतायु सर का नाम भी है क्या नाम है?
so what is your prayer?
My consultant prayer is that they have said that we have been allotted the shop to the private respondent.
Yes.
But we have said that as per the resolution of board of municipal function, the private respondent has been allotted. We have been given with the facts, not it's required affidavit appointment so that it can be brought in knowledge of this honorable court house of.
Affidavit in reply you want to
Affidavit opposition.
opposition. Then it will go for the petitioner. Raise for time to file affidavit in opposition. Let this matter appear before the next circuit bench. In the meantime, he is directed to file affidavit in opposition.
Obliged. 10.
Lordship, I am appearing for the respondent. Honorable Justice Amrita Sinha. Honorable Justice Amrita Sinha has passed the order. Lordship, when the same line, if the order is passed, I have no. May I place the order? Lordship?
Yes. Electricity.
Lordship.
Who is for the other side?
I'm for the.
It is only.
Same order can be passed.
Okay. I am also passing direction same day.
Obliged.
Okay.
Because coordinate bench lordship, so I don't want that separate order should be passed.
Thank you.
It should be in same line. Obliged.
And what? 11 and 12 both.
For the.
What is in the 12?
That is WP and connection of complaint case, lordship. I am for the state.
Please, my lord, I'm appearing for the petitioner in serial number 11 and 12, madam. Am I audible?
Yeah, who is there for? You are not visible, madam.
Am I audible, my lord?
You are audible but not visible. There is some disturbance in.
My lord, am I audible now?
Yes, you are audible but not visible.
Visible.
Yes.
Yes, she is visible. She is.
Here, it is visible in this connection.
Here,
Yes.
my. What is this matter?
My lord, this petition is arising out of 138 proceedings. My lord, on the last date, I had sought to argue, but my lord was of the view that
Yes,
since
yes,
respondents are absconding,
yes.
my lord, may I take my lord's attention to page number
Now you are.
39.
What is this matter? What
My
direction
lord, there's a very short issue involved. Once
on the joint? You are for the
I am for the original complainant, petitioners.
original complaining. Here, are you petitioner or
My
respondent?
lord, I am the petitioner, my lord. I'm appearing for the petitioner in serial 11 and 12. My lord, they both are connected matters. The petitioner in both the serial numbers 11 and 12 are members of the same family, and the respondents, the accused persons in both the connected matters are members of a separate family.
I am for the state respondent number 2, lordship. Private respondent has to be appeared because it is a complaint case, lordship.
Oh,
Order passed in complaint case.
My lord, on the last date, I had argued that my affidavit of service.
I can recall, private respondent is absconding.
Correct. And a LOC is issued, red corner notice is issued, proclamation is issued. That proclamation, despite proclamation, he did not appear.
To send notice to the absconded person who is absconding, they will not appear and service will not be completed.
Yes, my lord. That is why on the last date, I argued that my affidavit of service may be treated as good service because the envelope has returned as unclaimed. And my lord, the accused persons are absconding since the past 4 years. We do not know the whereabouts of.
I am not on that point. Whether it is good or bad, I am not on that. What is
Is my lord is hearing me on merits today?
what is the order impugned?
Yes, my lord. The impugned order is at page number 49. I filed an application for registration of FIR under section 174A because despite proclamation, the accused persons did not appear. My lord, my application was rejected by the trial court. I filed a revision in sessions court. Even sessions court has rejected my application. The impugned order is at page number 49, madam. My lord, the two grounds based on which the trial court rejected my application is first, that the proclamation is issued without outside the jurisdiction of this honorable court. Therefore, it does not have powers. And my lord, the second observation is that the accused is not declared as a proclaimed offender. My lord will see the order passed whereby proclamation is issued, 1 month notice was given, and he was declared as a proclaimed offender, yet he did not appear. So my lord, this is completely contrary to the facts of the case. And my lord, as regards the proclamation has to be issued where the accused persons are residing. Admittedly, the accused persons are residing in Surat, Gujarat. Therefore, the proclamation was issued within the local jurisdiction, my lord. But since the order of the trial court in Port Blair, the order has not been complied with. Therefore, the section 174 is very clear on this, that the FIR must be registered within the jurisdiction of the court who passed such order. My lord, the second impugned order of the Sessions Court is at page number 85,
Just a
whereby even the
minute,
Sessions Court has rejected my application.
just a minute, let me go through with the impugned order.
Very well, my lord.
You are well prepared, but I have,
My apologies, my lord.
just a minute, go through that. You are complainant.
Yes, my lord.
Case number 63. You are complainant of CR case number 63 of 18. Are you
My lord, I'm complainant in both the writ petitions. In both the these proceedings are arising, I'm complainant in both the matters.
CR case, you are referring impugned order passed on 29 November 2022.
Correct.
No, 18th April 2023. This is the impugned order.
Yes, my lord, that is the first order passed by trial court. I challenged in Sessions Court. That order is at page number 85.
Yes.
That order is dated 27th of August 2024.
Paragraph, which paragraph you are referring to?
My lord, page number 85, last paragraph.
Last paragraph. On perusal of record, I find that the instant case here already is pending.
My lord, then next page. The learned trial court should take steps so that the proclamation warrant be sent to the concerned police station for its execution. Suppose accused resides in different jurisdiction of the court, then it must be sent to the police station where the accused resides. My lord, further below, in the last paragraph, sixth line, since in this case WPA has been issued and it is waiting for its execution, hence I think complainant should wait for the execution report, as because the case has been filed for realization of money of check in question and the WPA execution report comes, then trial court will proceed accordingly. In spite of that, if accused does not appear, then the trial court will take appropriate steps. My lord, so the trial court rejected my application on the ground that the proclamation was not issued within the jurisdiction of this honorable court. Therefore, the trial court would not have powers. And my lord, the Sessions Court rejected my revision on the ground that the WPA is pending execution. Therefore, the order cannot be issued at this stage. My lord will see the proclamation is issued. The proclamation is at page number 39. Is my lord with me?
The accused is absconding.
Yes, my
Then
lord.
what is they used to initiate a new case under section 229A and 174A of IPC.
My lord, right now we are still apprehending his arrest because we have not been able to apprehend him yet. Since 4 years he is absconding. My lord, the difficulty is that we don't know where his whereabouts and but they both are together. Why they both are absconding together. As of today, we don't know his whereabouts. My lord, it is our understanding that if an FIR is registered, at least the police will come to some aid in tracing the accused or doing that, because that court would not come to our rescue. I believe that the police machinery will be helpful in tracing the accused persons, my lord.
Yes.
And my lord, as regards the remedy of the petitioners, my lord, we have once the offense is committed, my lord, whether it is effective or ineffective, that is a separate issue. But my lord, as regards this petition is concerned, once offense under section 174A is committed, my lord, directions ought to have been issued for registration of FIR. May I read section 174A, my lord?
Whereas in set aside the improved order drafted. Yes, please, sir, can you throw some light?
Lordship,
Yes,
ultimately,
my lord.
the
Kindly come to page.
absconding.
My lord,
Accused is abscond.
my lord, please allow me to complete my submissions, my lord. Then the respondent may begin his submissions.
I'm-
My lord will kindly
I am
come to.
coming to you.
Oh, well, very well.
Yes,
Warrant was issued. Could not be executed.
in which case?
In CR case,
CR case. CR 63 of 2008.
Lordship,
Where is the copy of said CR case?
that
My lord, I am arguing from the petition at serial number 12 because they both are exact same.
Where is the copy of your CR case?
order is there, but copy.
My lord, my application is annexed at page number 41. My application of the CR case, my lord, but the CR case is, I have not annexed the CR case. My lord will see at page number 41.
41 next,
CR 62 of 2018.
of the application, copy of the complaint upon which the CR case was started.
My lord, that is not annexed.
Yes, copy I
Copy is
also
not
did not
registered.
find.
Where is the copy? LCR?
Copy, yes, yes, but
Learned advocate for the petitioner appears virtually. Complainant is PC set.
Yes, and P. Prakash Sheth and Daivi Sheth.
You are representing complainant.
Yes.
So private complainant is represented by her. And other side is accused. Hina is accused.
he's absconding
She is
Yes.
a-
Hina and Ramesh.
by the London trial,
Hin-
as the session court in the criminal division.
petitioner is present. And accused and or other respondent are not present. So number of attempts were taken, they are absconding. So there is no possibility of their presence
In the this court,
in this case.
this court, Lordship.
So you may represent and
Lordship, order have been passed by the trial court, that this is judicial magistrate in CR case. That
Yeah.
order have been challenged before the session court.
yes,
That have been challenged before this court by the complainant.
Yes.
Then I will argue the matter for proper adjudication of the case.
yes, that's all.
Whether that order have been
When should I fix it?
any date, Lordship, as per the convenience of this court, Lordship.
Is present. Respondents are not represented.
Respondent number one, Lordship, sorry for it. Respondent number one.
Respondent number one is absent. However, respondent number two is represented by Namdev. He submits that for proper adjudication of this matter, LCR is required. Call for LCR. Could we get it by Friday? No, Monday. Call for LCR.
Monday, Lordship.
Let this matter appear on Monday.
आप है ना? आप है? Petition. Please.
One more direction. In the meantime, member secretary of SLSA is directed to appoint one advocate to represent respondent on the adjourned date. Respondent. From panel, appoint one advocate from the panel of advocates. It will appear on Monday.
We will serve a copy of the petition upon the appointed advocate. My lord, may only record my formal objection to the appointment of the advocate.
What problem you have?
And my lord, my only concern is that they are not willingly appearing. They don't have any regard for the judiciary, Indian judiciary. Since 4 years, they are not appearing. My lord, this order, in my respectful submission, the order partem cannot extend to that level that even if they don't want to appear, still, my lord is kind enough in giving them legal aid.
Course against them. You are not required to bother.
Sorry?
Next.
I am obliged.
Thank you, madam.
My lord, item
That
number 12 is similar to the item number 11.
11 and 12 both same.
Same, identical match. Same husband.
No, in both case. Okay. So same order.
Yes, my lord.
11.
Same
You
order.
are in item number 12. Both are same case. Arising out
Same case, my lord.
of. Okay. Both will appear on Monday.
Yes, my lord. I am obliged.
Your lordship, in this matter, Mrs. Nag is appearing for the revisionist, your lordship. I pray for short passover in this matter.
Short pass over.
Lordship, item number 1481, Mr. Mohammed Sargej is appearing, Lordship, due to illness of his father here, out of the station, out of the island, he is in Chennai. So can it be taken up in the next circuit bench?
On the ground. Yeah, none appears on behalf of the. No, on behalf. Led,
No. Here is present.
present.
Present is not in court. We are told that sir is not available.
On the joint prayer of learned advocate for both sides. Let this matter appear before the next circuit.
Problem.
I got the response.
Who is for the petitioner?
He was present today, he was not present today, he just said, his matter might be tomorrow, he will come tomorrow, and then we need that, and placing to judgment.
In which case, where is the case?
Similar that is matter, the case was in the petition was quashed. This elaborately is mentioned about the cognizance regarding the section 188, 172 to 188.
Yes. Yes,
The matter may be.
so he has concluded his argument. And learned VP, you wanted to go through with some.
I wanted to go to the judgment which was passed by our high court. Can you come to the improved judgment? Lordship? That judgment.
Where is the judgment?
Within the record.
Yes.
May I read, Lordship? The revision application under section 482 1 code of that second paragraph. Lordship, I will come to the second paragraph. Dear cut number was initiated on a complaint submitted by Sub Inspector Subramani SHO PS Calcutta on an incident of gathering and Muthu Mariamma Temple, Gandhinagar, Bengaluru on 2nd July 2020 on the occasion of puja ceremony, violating the COVID-19 protocols in terms of order promulgated under section 144 of CRPC. Next page, Lordship. With effect on such and such date. The case was investigated, charge sheet was filed and in the accused, including the petitioner under section 188, 268, 269, 270 of the 34 of Indian Penal Code, read with section 51 of B of Disaster Management Act. In this case, this section never charge sheet filed. Disaster management. After submission of the charge sheet, learned judicial magistrate Camberwell took cognizance on 12th of
Investigation and charge sheet was filed.
Yes,
And
charge sheet and
in this case, and where is the charge sheet?
charge sheet.
Charge sheet of the this regional application. Yes, charge sheet.
Charge sheet.
Charge sheet under section
188, 269, 270, 34.
There is
Yes.
no DMF.
So 51D
DMF is not in the instant case, Lordship.
Yes.
So in that judgment, 51 of Disaster Management Act was there. Then what happened thereafter? Took cognizance on 12th October 2020 and subsequent date was fixed on 6th January 2021 for examination of the accused under section 51 of the Code of Criminal Procedure. On that day, substance of accusation was read over and explained in the accused, including the petition who pleaded guilty and learned magistrate convicted all the accused, including the petitioner for committing offence punishment under section such and such. India with offence punishment under section 51 of Disaster Management Act 2005. In that judgment, Lordship, the accused person pleaded guilty, Lordship.
Oh.
Pleaded guilty. Then On careful perusal of the entire materials on record, it comes to my view that actual the prohibition under section 144 of the Code of Criminal Procedure was promulgated by district magistrates toward the Nicobar district with effect from 30th June 2022 till 31 July 2020 in compliance with the order of Minister of Home Affairs for containment of COVID in the country by order number such and such, dated such and such. Concerning the entire fact enumerated in the report in final point, find that the case was started on the report submitted by SI Subramani SHO Kappalpe, and in the complaint there is no specific allegation against any of accused, including the petitioner. It is the vital thing, Lordship. Entire charge sheet, the Honorable High Court found that in the complaint there is no specific allegation against any of the accused, including the petitioner. All the sections put in the report in final one alluded to violation of COVID protocol, which is punishable under section 51 of B of Business that is Protocol Act, 51B, Disaster Management Act. Lordship. Next one. Mr. Gopala Kumar Lane, advocate appearance of the petitioner, has referred to the section 60 of Disaster Management Act 2005 and submitted the cognizance taken by the Lane Minister was bad and not accordance with the provision of 60B of the Act of 2005. Lordship, this is the point. Because Disaster Management Act, section 6, there is a bar, 60. So the cognizance was bad. Mr. Gopala Bindu Kumar has further submitted that cognizance of the offence punishable under section 188 of Indian Penal Code cannot be taken by the court except the provision mentioned in exception clause under section 195 of the Code of Criminal Procedure. Thereby, Mr. Gopala Kumar has contended that London magistrate did not have power to give cognizance of the offence under section 180 of Indian Penal or under 51 of B of Disaster Management Act 2005. Then Mr. Salim Mohammed, London advocate appearance who have listed, has considered that London magistrate did not have authority to take cognizance of the offence under section 180 of Indian Penal Code, as well as the offence punishment under 51 of Disaster Management Act. Mr. Salim has submitted that London magistrate had the authority to take cognizance of the rest of the offences punishable under section 269 and 270 of the Indian Penal Code. After careful scrutiny of the entire record, including the report in final form, I find that entire allegation against the accused, including the petition, is revolved around the violation of COVID protocol within the meaning of section 51 of Disaster Management Act. Lordship. The alleged offence under section 269, 270 of Indian Penal Code. I am of the humble opinion is not applicable within incorporating section 180 of Indian Penal Code and 51 of Disaster Management Act. In fact, the offence under section 269, 270 of Indian Penal Code cannot be said to be existence without the offence punishable under section 51B of the Disaster Management Act 2005 in terms of the case of prosecution. According to provision of section 60, court cannot take cognizance of an offence under Disaster Management Act 2005 except on a complaint by the authority prescribed in section 60A(b) of the Act 2005, and it is needless to mention the SHO complaint does not fall within the authority within the meaning of section 2 of the Disaster Management of 2005. Therefore, with the aforesaid view of the matter, I can easily come to the conclusion that cognizance taken by the London magistrate of the office elected in the proceeding is bad and liable to be lost. So, Lordship, the judgment was passed by our Honorable High Court, Lordship, maximum emphasizing the section 51 of the Act regarding 269, 270, 188. That was the main principle of that case.
Yes.
And the main allegation against these accused persons totally different. And who is the complainant, Lordship? That Rajesh is authorized by the Deputy Commissioner. He was authorized by the Deputy Commissioner because he was
From where we get?
Lordship, kindly come to the charge sheet of the written complaint of that person, Rajesh Kumar. Just a minute. That application,
Written complaint is with the charge sheet.
yes, the part of the charge sheet. May I read also? I have the case.
Yes.
May I read also?
Yes, yes.
To Thana Adhyaksh, written by one Rajesh Ram, Lordship. Mahaday, निवेदन है कि मैं राजेश राम son of such and such गांव का चौकीदार का पद पर फरागन तहसील में कार्यरत हूं। He is the चौकीदार that is under Deputy Commissioner Revenue Department। तथा मेरे साथ श्याम नारायण son of such and such के पद पर कार्यरत है। हम दोनों का इस समय
चौधरी पद, चौधरी
चौधरी
चौधरी, what is Chaudhary?
चौधरी
Chief of the village.
not king of the village lordship, he actually used to collect land revenue. He is the staff of the revenue department.
Oh,
Chaudhary.
The comparator is the Chowkidar, it's not a Chaudhary.
Yes, Chaudhary.
Don't miscelebrate.
no, there is nothing to misinterpret. Rajesh Ram was Chaukidar
Chaudhary.
and Shyam Narayan
Yes,
was the Chaudhary.
Chaudhary. Yes.
There is two person.
है हम दोनों का इस समय कोरोना वायरस के चलते कि लोग को होम आइसोलेशन किया गया है, उसमें सूचित करने के लिए मीठाकारी, नमूनागर, डंडस पॉइंट के इलाके को सभी डिप्टी कमिश्नर के कार्यरत से दी गई है। नॉट क्लियर लॉर्डशिप, सॉरी फॉर
Clear, Deputy Commissioner के कार्य से दी गई है।
दी गई। उसने से एक श्रीमती सोमिया
सुल्तान
जो कि मीठाकारी विलेज का रहने वाली है, उसको दिनांक 23 मार्च 2020 को बताया गया कि तारीख 23 मार्च 2000 के 5 अप्रैल 2000 तक वह अपने पूरे परिवार के साथ घर पर ही रहे और वो घर का कोई भी सदस्य को घर से बाहर निकलने के लिए मना किया गया था। आज दिनांक दैट इज डेट ऑफ ऑफेंस 25 मार्च 2020 को सुबह के समय करीब 10:30 बजे मैं और श्याम नारायण ड्यूटी
सूची बांटते और चेकिंग
करते हुए मीठाकारी और नामिनागर क्वारी का तरफ जा रहा तो देखा कि that lady's name का पिताजी अब्दुल हकीम तथा उसके भाई फारूक दोनों नमूनागर में पिकअप वैन से कहीं जा रहे थे, तो रोकने पर नहीं रुका। पश्चात फारूक से फोन करके पर उसने बोला कि आप लोग मुझे और मेरे परिवार को परेशान कर रहे हो, मैं और मेरे पिताजी घर से बाहर निकलेंगा, आप लोगों को जो करना है कर लो। So lordship, he is the authorized person, he is the revenue person, authorized by as per the notification, he is the authorized person. He tried to stop because that was a quarantine. So regarding that disaster management, that order has been passed, that is Honorable High Court lordship. In this case, lordship, totally not applicable because here only 188, 269, 270 of the IPC lordship, charge sheet already submitted, authorized persons, that entire fact, entire disputed question of fact can be raised at the time of trial lordship, not at this stage lordship.
My learned friend started learning.
Yes. No problem. Did you serve copy of this judgment?
Few things I want to submit. Your Lordship, we are governed by the CRPC. Section 195 clearly says that section 172 to 188. The written complaint has to be filed by the person, the public servant officer. As per my learned friend, he says
Whether
that
Chaukidar is
Chaukidar-
public servant?
No, Chaukidar is not.
Chaudhary is public servant?
Chaukidar is just lowest public servant. But
But he is public servant.
Yes,
Lowest and
yes,
highest is
yes,
not a question.
And the deputy commissioner, the order was passed by the deputy commissioner. The violation has been violation of the order of the deputy commissioner. He is the person who has to write the written complaint as per the section 195 to the court. This is the procedure. Then the court will fix for the inquiry.
For 188,
180. Yes.
but what about the remaining other?
188 section will be not incorporated. Automatically section 260 and 269, 270 will be deleted.
How?
Because it is related with the section 188. related with that, it is there in the order. Kindly come to the order passed by the Justice Bijan Ranjan Das in the para. Page 4, you should kindly come to page 4. After carefully scrutiny of the entire record including report in the final form, I find that entire allegation against the accused, including the petitioner, is report around the violation of the COVID protocol within the meaning of the Section 51 of the disaster management. The alleged offense under Section 269, 279 IPC, I am a humble opinion, is not applicable without incorporating Section 188. So here the 188 section itself violated. The provision of the CRPC has been violated by the police. The police has directly shot out the FIR. And the person who is the whose order has been violated, he is the DM. He is the person who has to write. Otherwise, the subordinate officer is the SDM. He has to file the return of complaint.
No, DM may authorize someone.
Judgment which I have given you. Lordship, I have annexed. Kindly come. There is elaborately mentioned in para the judgment of Rajesh Rathore.
Yes.
Para 23, the matter so and so, so and so. The Supreme Court in the matter, Basirul so and so, need so and so. The kindly come to the last paragraph. No FIR can be registered under Section 154 of the CRPC of IPC of the court for at least.
Last paragraph.
The last page of this para 23. Para 23.
Yes.
The last line. It has been held that no FIR can be registered under Section 154 of the code for alleged commission of the offence under Section 180 of IPC by observing 30 form prospectus of the post-state judgment rendered by the Lordship of the Supreme Court in Madras High Court. It is quite vivid that order to prosecute an accused for an offence under Section 188 IPC. It is imperative to undergo the procedure envisaged under Section 195(1), Clause 8, subclause 1 of the code. Complaint in writing by of public servant concerned or some other public servant to whom he is subordinate. Otherwise, cognizance of offence Section 188 of the IPC cannot be taken. And if this imperative procedure is not complied with, the entire prosecution for offence under Section 188 of the IPC would be rendered at an issue. Why at an issue? As Section 195 of the code.
No, so who will decide that whether procedure were followed or not?
Kindly come to the last.
These are the.
Kindly, in the same paragraph, the last line. Therefore, the first information report also cannot be registered in the Section 154 of the code for offence under Section 188 of the IPC has registered of FIR. After investigation would culminate into the police report under Section 173A(8) of the code, which cannot be taken cognizance by the magistrate under Section 190 of the code. As such, registration of the FIR for offence under Section 188 is barred. And another ruling which I have given is Haji Usman Haji. In that there are 3. Haji Usman Haji Suleiman. In that there are 3. Any detail?
Yes.
Learned Advocate Mr. Deepak Singhi, appearing on behalf of the applicant, in both the application has contended that the FIR against the applicant is a gross misuse and abuse of the process of law. He has further contended that as per the Section 195 of the CRPC, proceedings under Section 188 of the IPC can only be initiated on the basis of the complaint in writing of the public servant concerned made to the court or to some other public servant to whom he is subordinate, administrative subordinate. Section 195, clause 1 of the CRPC restrain the court from taking cognizance of any offence punishable under Section 188 of the IPC unless a complaint in writing is made to it by the public servant concerned. Here, the complaint is not lodged before the court as per the Section 195. Same line, I am continuing. Unless a complaint in writing is made to it by the public servant concerned. In other words, no FIR can be registered by the police it would not be open for the police to register a case against the offender for the offence under section 188 of the IPC and to submit the report under section 173 of the CRPC to the concerned court. Here the FIR has been just one call. He has called the registered complainant has just called to the Tahsildar. There is no written authorization to the concerned Rajasthan to
Okay.
lodge a complaint before the police. He directly lodged went to the police station and lodged it. And the
Yes.
police without
As per you,
as per-
section 88 is not retracted.
not
Cognizance is bad. Proceeding should be quashed.
yes, and apart from that, if there is no DM Act is there, so automatically section 260 and 270 is not applicable. Because because it is all in the matter is all depend on the protocol of the COVID protocol. So violation as per the notice affixed in the house. So this DM Act should be added, but there is no DM Act is there.
Why?
It is the
Oh, yeah.
it is, and apart from that, the notice was issued to Soumya Sultana. These petitioners, their name is not there in notice. My public prosecutor show that the notice was issued to them. Then it will be
No,
different.
notice was not regarded. That was the general.
Notice is particularly issued to the Sultana, Soumya Sultana, not to these particular persons. No, it is there in the.
No, they are the family member of some society.
If the girl lady is family member, he was taken as the quarantine, the isolated place that is home. Nobody come into the home, nobody has to go outside the home.
Oh, he was under quarantine.
Maybe
First time.
they are residing in some other house. The family member is not the criteria. The notice was issued to Soumya Sultana, not to the applicants. There is no
Then
notice-
it means the
there is no
proceeding,
notice there.
proceeding against Soumya Sultana is correct.
No. No affair.
You are submitting like that.
Against Soumya Sultana.
You are submitting like that.
Why
Why are you-
Just.
Why are you digging?
Yes, yes. And so.
No, it's short, one minute. Roshi.
Yes, yes.
195 kindly appreciate this part, whether applicable or not.
195.
195 of the CRPC Roshi. That is 195 AI 23. Then next, except
ये
CRPC.
এই বন্ধ করো তো 17 পর করে একদম গায়ে আসছে 195
195 A Roman I 2 3 then paragraph except Lordship except
yes
except on the complaint in writing of the public servant concerned. Kindly see the language. And who is the chowkidar and that person concerned or of some other public servant to whom he is administratively subordinate. Then FIR went chopped out Lordship on the basis of that complaint written by that person.
and he was interested by the
Lordship.
DC.
And if he was not interested or not interested, that is the purely disputed fact question of fact.
Disputed person.
Then be taken into trial that no notification, no order, nothing. So clear cut provision 195 not at all applicable in this instant case. Because written complaint in Hindi was sent by the Rajasthan. Being a revenue staff who was duly notified and given a power to see who are the person quarantine, who are the moving here and there. First point. Second, my learned friend saying that without 188, 269 can work. You can see the definition of 269. Lord. Of IPC. Negligent act likely to spread infection of disease dangerous to life. Whoever unlawfully or negligently does any act which is and which he knows or hasn't reason to believe to be likely to spread the infection of a disease dangerous to life shall be punished. whether arising out of section 188 or not, they were under quarantine. And during that period, there is a notification of the government of India. There are the certain guidelines, no gathering. Then 270 lordship can come next one, 270. Malignant act likely to spread infection of disease dangerous to life. No connection with 188 lordship. And that's High Court judgment lordship depends on that 51 of Disaster Management Act. That is not all maintainable in the state case. I pay this application.
I have the judgment all in the related to the.
That's all. lordship.
Your lordship kindly come to my.
No, just
One line, your lordship. Kindly
not
appreciate-
cross argument.
kindly appreciate-
No cross argument, sir. No cross argument. If you have anything,
Your lordship.
On-
I will be
no.
allowed. The public servant means he is saying the Rajasthan, assume the public servant is the Rajasthan. I accept it. But he has to file a written complaint under section 195 clause 1 CRPC, but he has not filed the complaint under section 195 CRPC. He has directly chunked out the FIR.
Yes.
to the police station. So there is a violation, which is the settled law.
order will be passed.
Obliged.
Yes. Call the meeting.
Lordship, I am appearing for the respondent.
Yes.
Petitioner has to file their reply.
Who is for the petitioner?
My senior Vishal Kumar Vishwas appears for the petitioner, seeks some time to file a reply in accordance. Due to ill health condition, he could not.
On
able to-
on the prayer of learned advocate for the petitioner. Let this matter appear before the next circuit bench. He is directed to file affidavit in reply, if any, in the meantime.
Obliged.
24.
হয়ে গেছে 29 পর্যন্ত হয়ে গেছে 30.
You know, 30.
Lordship, item number
30.
I have to take instruction. Lordship.
You know, let it be on Friday and for the private respondent, I had served the copy. I had filed my service, affidavit of service. So let it be on Friday, my lord.
Let it be on Friday. I will take instruction and come back. Lord.
On the joint prayer of
Service complete, my lord. I had filed my affidavit of service for the private respondent.
on the joint prayer of learned advocate for both parties. Let this matter appear on 30. 13th আছে Friday. Serial number 24.
The service certificate to be levied, because I had filed my affidavit of service before the reach. That may be recorded.
No, in 38, 31, both.
No, only 30.
Okay.
I had filed my affidavit of service. That may be taken on record.
Where is the affidavit of
Registry I had filed,
first you দেখুন affidavit of service আছে আছে দেখি কবে ফাইল হয়েছে You are for the
I for the petitioner.
petitioner. And
Respondent.
yes,
is the private-
respondent
I am
is-
appearing for official respondent. Private 4 is the private respondent.
oh,
Let it be on Friday, Lordship. I will take instruction and come back.
affidavit of service, whether private service against the private respondent is completed.
I got the information that official respondent also not served, because they have handed over the one copy. But it has been served or not, I do not know.
Sasi Kumar. Yes, it has been received by Mukh Sachiv ka Gopniya Sakha on 7th
Actually,
October
what
24.
happened, and we had south of three post secretary.
What about respondent number 2 and 3? They are the main respondent.
Council is appearing for the respondent authority for all of them. I had given a
Lordship,
copy. If
Lordship,
you
I
want,
have
I
received
provided
a
a copy.
Electricity Department also received it.
Everything is there. Lordship, let it be on Friday. Lord. I will take instruction and come back.
If my brother wants, I'll give another copy to my landed brother.
That will be helpful.
And
for us.
AE
Sending him.
P oblique Pur. Office Electricity Department. They received long back, 7th of the September.
No issue. If my brother.
Let it be on Friday. Lordship, let
I have
it-
no issue. I'll
And-
give an estate copy. I'm having.
Learned advocate for the petitioner. Whether it has been taken on record or not.
No, the affidavit of service was not taken on.
Learned advocate for the petitioner. Files affidavit of service against the respondent authority number, respondent number 1, 2, and 3. And one postal track report against the private respondent number 4, from which it appears that item was delivered on 10th October 2020. The service against the respondents are completed. On the joint prayer of Learned advocate for the both sides, let this matter appear on Friday. Yes, Friday.
Lordship.
24 to 29 was what?
Not sir.
Not odd. Serial number 24 to
Same
24.
No, 24th.
Petitioner is different.
Different. Oh, the call serially. Call serially item number 24 to 29.
Lordship, I have filed my affidavit in opposition. I have searched the other place.
And someone pray for time. Who is for the, you are for the respondent? Who is for the
Mr. Prakash.
petitioner? Yes. Perhaps adjournment was sought for. কোথায় গেল লিস্টটা কোথায় গেল लिस्ट लगता है चल गया उसमें हाँ प्रकाश मींज तो प्रकाश मींज इन ऑल 24 to 29 सब में तो एक ही আছে
24, 25, 26, 27, 28, 29, 30 is not mine, 31, 32, 33, 34.
yes
My lord, the instruction is given by the honorable court that copy has to be sent. My lord, Yesterday only I came from Ireland. So today I will sub matter and maybe fix on the after that is on Friday matter.
Very well.
Instead of Friday, can it be on Monday?
Monday there is.
Last day.
So
Don't-
this is with regard.
Don't put torture on
Yes,
me. Huh?
Let it be on Friday.
Very well. On the joint prayer of learned advocate for
I
the
am not
person.
praying, Lordship.
Oh, sorry.
Because he has-
Learned advocate for the petitioner prays for adjournment till 13th. Let this matter appear on 13th. Learned advocate for the respondent आगे दिए तो is present. Yes, 13th.
Lordship.
31 डाकुन 31.
31 also same.
29
next week. 31 to
Oh, 31.
29 next week next week 29 next week
ना ना 29 सब अच्छे इंक्लूडिंग है. नेक्स्ट सर्किट बोलती होगे तो फ्राइडे को बोल रहे हैं. नेक्स्ट there is no any barrier to make a submission from 35. Thank you.
Lordship, I am very for the respondent of the Lordship. I have received the instruction, Lordship, his application has already been rejected.
That's why I need for your Lordship.
No, he has not.
Once rejected,
disclosed
then
that
what
rejection
direction
order.
you?
He has not
Authority has
disclosed that-
rejected. Then what direction you want over the, now
This is the.
no representation is pending before the authority.
Yeah.
Then what direction should I give?
Not-
Already decided, either in your favor or you are against. If the matter has been
This is,
decided,
this is the status report. It is available in the internet also. Before filing, it would have been checked.
learned advocate for. Do you have anything to submit? No. Learned advocate for the respondent. Yeah, liberty is always there.
Always there.
You may make a number of representation before your authority. For that, your direction of this court is not required.
No,
No, no.
that
You
I
may make
can't.
fresh representation before the authority for new correction. Once rejected, it doesn't mean that your right to make. Yes. You are always at liberty to make a. Learned advocate for petitioner, respondent submits that the application, the representation which was pending before the respondent authority has already been disposed of on 27
2024.
September 2024. That is prior to the filing of this application, writ application. Since there is, since no representation is pending with the respondent authority, the instant writ, instant petition become infructuous. Accordingly, the WPA 660 of 2024 dismissed as infructuous. Yes.
Lordship, let it come on Friday, Lordship, I have to take instruction.
36.
Such.
Uh,
Yes, yes, I
Sir.
am not objecting to it, I am very.
on the prayer of learned advocate for the respondent, let this matter appear on 30th. 13th. Yes. Appearance of petitioner ये पढ़ने को.
37,
Okay.
38, I have not received any copy. My learner senior are giving me a copy, I will accept it and let me take instruction.
So should I fix it on Friday or Monday?
Let it, two matters, let it be on. Or else I will be not having any matters because the lordship from Monday. I will be missing.
Okay. Same is here. Yeah, on the prayer of वही थे ना Monday.
Monday.
37 and 38.
So like.
ये कौन है? 429. Yes.
Lordship, I will not make it.
Thank you. FMAT 8 of 2020.
Respondent insurance company.
Yes.
There's this point of information is to be done before the decision.
Not required. Not required.
I've already given them.
163A. 2 points. 2 points was there. Minimum 5 lakh and date of interest from the date of filing of. Only 2 issues are there. Do you have any objection?
No, I am not ready. The matter is tomorrow. I will not.
Okay. On the prayer of learned advocate for the respondent, let the. Yes, yeah, not required.
Required, very much.
Not at all required.
No, very much required.
Not
Why I
at
am
all
saying, interest part, court has to see whose fault
No,
from the record.
that is already settled by the honorable Supreme
No,
Court.
no.
Not
that is
at all
required.
required to look into.
Let
You
the
find
LCR
it,
call for.
whether it is 10 years, 20, even
Because of your mistake, you
No.
are not ready.
Okay. I am giving direction. On the request of learned advocate for the respondent, let this matter appear tomorrow. In the meantime, LCR of this case, LCR of MSCT case number 40 of 2016 be called for. LCR liquid, TCR ticket. Be called.
There is another respondent officer. I am appearing for interview.
already served, already served.
Other respondent is owner or driver.
They never appeared also before the learning.
Maybe, but they are part.
Don't be so technical.
I am not taking.
I know whether service has been made against him or not. Service has made. Where is the service report? Dito. Record. Against respondent number 2. Let me see. Where is the track report? Track report is not first.
Down is very difficult to get. Track report is next to impossible.
How could no?
Then incomplete service.
It was sent on 11th of the November 2024. Track report would be easily available. File track report.
In submitting the opposite party, that is the owner of the vehicle, he did not choose to appear before the learned court.
Maybe. Then why you made him party?
It may be, but you file your track. Will pass order.
Upon him,
Then
in
you
any
then
circumstance.
you file application for decision.
These are technical things.
You are insurance company, sir, and you are duty bound to.
Yes, like that. No.
Okay, we'll hear you.
Sorry.
We'll hear you tomorrow.
Yes.
For the important system, tomorrow they can probably use now, but for the instruction card, it is that will be where there will be next.
On the prayer of learned advocate for the petitioner, joint prayer. On the joint prayer of the learned advocate for the both side, let this matter appear before the next circuit. Yes. Who is in item number 41? 42? Item number 42? No, 41.
41.
41. 296, 2930. None appears.
41 I appearing, Lordship, online.
Yes.
The host had actually closed my video. 39 actually, Your Honor, the Lordship, a small incorrect submission was made on the last occasion because we did not have the copies of the orders. This instant complaint case has already been dismissed in 18 November 2014.
Now, whether this matter has been settled?
Lordship, it was settled way back in 2013-14 and subsequently the complaint was dismissed on 18th November 2014. The erstwhile advocate on record never brought it to the notice of any court and subsequent and it has been pending since languishing since 10 years.
18th November
2014, Your Lordship.
Complaint has been
dismissed.
Where is the order?
Lordship allows me to kindly directs the court officer to allow me screen share. I will show the order on the screen.
Oh, this is a case relating to 138 of
138, a check, dishonor of check of amount of only 54,000 back then in 2009. 2012, this matter was filed, never moved properly. In between, the parties had settled. Those were my instructions. And in 2014, the matter has been dismissed. I have a certified copy in my hand. I can also show across the screen if I'm permitted to share my screen.
Where is the order?
Lordship, order I have to show here. It is in my hand and I can show it over the system. The host is not allowing me to screen share the document. It will be on your Lordship's desk.
Who is for the West Bengal state?
Lordship, complaint case state nowadays does not appear.
But
it was a private matter.
State is party.
State was parties. Those days we used to make parties. Nowadays the system has been, state is not appearing. State does not, if I may put it this way, appoint advocates for these matters because state is not concerned in private complaints.
Okay, this matter appear on after two.
Lordship, it has been already, kindly allow me to screen share the document. I will just demonstrate that the matter has been dismissed in November 2014. Lordship can dismiss this matter.
You sent the copy.
I can show it right now.
Yeah,
I can show it.
After two, we'll sit with after two, and by that time you do necessary.
No, I can show it right away. Kindly ask the officer to allow me share the screen. Only 1 minute will take, Your Lordship. I am having in my hand and I also have a soft copy.
Share screen. इसमें 2 बजे के बाद ये करते विल सिट विथ in second half. By that time they will do everything.
Okay, Lordship.
They will make contact.
I will try to send an email. I'll just ask your court officer. I'll send it by email.
Sure.
Okay.
42. Who is in
On
42?
several occasions, my lordship, exercise was undertaken to serve the authority. It was done, their interest was protected by
Finally.
lawyer. Again, my lord has directed to serve again. I have.
No, the Union of India is represented by Mr. Tulsi Lal. He is there. Why are you searching Union of India here and there?
There are other.
He is sitting in near you.
There are other authorities.
This is a very old matter. Mr. Lal, this is a very old matter. So you are requested to take this matter so that yes, of course they will. And who are the other party? And who is for the Andaman and Nicobar
Point
administration?
number 4, 5, 6 have been again asked to serve. I have dispatched it on 4th of December. And I got the track report. It says office closed. But kindly have a look to the affidavit of service, which is already on record.
Webcon, managing director. What is this Webcon?
Just.
So you may serve notice upon the lieutenant governor.
Sir Rakesh, please.
Oh, you are for lieutenant governor. And chairman come managing director, National Safai Karmchari Finance.
This has been made, not
Made.
already. It's on record.
Who is for respondent number
No
3?
one have
And 4 and 5 managing director.
third time lot service are attempted.
Where is the affidavit of service?
Filed it.
No, this has been sent on the 15th January 2020. Where is the press one?
Certificate of service found on 10th of December 2024. Fresh one. 10th of December 2020.
10th of December 2024.
What would see the track report? What would find it shows that office closed, unable to deliver. What would find it at page number 4.
Page number 4.
4.
Office of?
Sir, office at
Office closed.
4, 5, and 6.
Office of?
Status not to see. In the tabulation, not to find. Status office closed.
Now, which office?
Office of this respond number 4, 5, and 6 at Calcutta.
What is in this matter?
I have been terminated even without issuing a formal show cause notice.
Who terminated you?
The respond number 4, 5, and 6.
They are private entity or
No,
government
they are
entity?
state under Article 12.
How?
The appointments are being done by the administration. The fund is being given by the administration.
No,
The administration is having a pervasive control. So they are state under the Article 12 of Constitution.
but first you serve notice and copy to Mr. Lal, and I think Lieutenant Governor is ready. So where should I fix it?
Take instruction from the.
Would you be able to take instruction within my stay, or should I fix it?
Ministry of Science and Technology.
It will take time. Okay. Then, affidavit of service submitted by landed advocate for the petitioner is taken on the record. It appears therefrom that service against respondent number 4, 5, and 6. Who are the respondent number?
4, 5, 6 and 8.
4, 5, and 6 in the writ petition could not be effected as their office was found closed. Closed or locked?
Closed. Office closed, unable to delete.
However, Mr. Procedural usually represent Union of India in this court is requested to represent Union of India in this case, in this matter. Learned advocate for the petitioner is directed to serve a copy of the writ petition along with necessary document to Mr. Lal on the prayer of Mr. Lal. Let this matter appear before the next circuit bench as he need time to seek instruction of Ministry of
Science and technology.
Science and Technology. Let this matter appear before the next circuit.
Blair, please. Here also, Lordship, I have
Okay.
taken pain to serve Mr. Lal.
Same order.
And
Service has been effective.
the affidavit reply is filed by the one of the respondent. If the copy is given to me by the respondent of three.
Now, what is in this matter?
What's the proposal?
Respondents are present, all respondents, Union of India and BPCL, IOCL. So who is for the BPCL and IOCL?
Report number 1 allowed. Could be instructed with the getting a pass through rate, item number 43, 45, 46, and 47.
For Passover or?
Passover, short passover.
Okay.
Item number 43, 45, 46, and 47.
43
46, 47.
Passover. Yes. Forty-four. Yes. Where is? Yes. What? What is in this matter?
Conviction against Appeal against the conviction and that was.
Oh,
Not within 2022 it was fine.
so, are both of you ready? How much time will take?
What time will happen?
Few part, few points. After 2 p.m. After 2 p.m. it's up.
After, yeah, plus long pending I want to.
Yes, sir, I will dispose.
6 witnesses only.
I will dispose.
Item number 45. I would like to
45.
I would like to mention what Mr. Tabrez is appearing for the writ petition. So I have earlier mentioned that he has taken his father to Chennai for treatment. So let it be in the next circuit, sir. Item number 45.
Order has been passed. You may submit on the when it has been fixed. Friday.
It has not been passed over.
Oh, passed over. Yes, yes. 45 and 46. Yes, on the you are on behalf of
Mr. Mohammed Tabrez.
yeah. Learned advocate on behalf of petitioner on behalf of learned advocate for the petitioner. And Mr. Tusilal, WPA. On behalf of the learned prisoner, let this matter appear before the next circuit bench.
For Blair.
45 and 46 both. Yes, 48.
Okay. It will not be members. The family study is in engagement with number 1.
Not today.
They are ready for next.
On the prayer of learned advocates for the both side, let this matter appear before the next circuit. Same next circuit.
Just, I will think for the. Service has been affected, but it has not delivered to the party.
What is this matter? What is this matter?
Ambassador case. Ambassador case. Compensation.
You are for the director of transport.
Chief.
And who is for the Suban?
After service.
What is the
After service, service.
or not effective? Learned advocate for the petitioner prays for time to effect service on respondent number on respondents. One respondent,
All the.
but only name of only one respondent
Right.
on respondent. He is directed to file affidavit of service within a week Let this matter appear before the next circuit.
My lord, my team is acting for petitioner, 52 to 55, I'm praying it's for next circuit. my lord.
Next circuit bench. Yes. Call the list.
Appeal for respondent number one by Lordship, Director Mr. Vinci.
Respondent number 1.
Yes.
And who is for the petitioner?
Yes, just not.
Not today. Not today.
Opinion is conflict for petitioner. Actually, paragraph is that for Salman. I pray for next circuit.
I'm appealing for respondent number 2 to 4 by Lordship, Director Mr.
On the prayer of learned advocates for the both sides. Let this matter appear before the next circuit.
Here I am appealing for the respondent by Lordship. Already I filed my appeal in opposition and serving.
Who is for the petitioner, sir?
Chairperson.
Pasova? Not today. Not today.
I'm serving a copy of appeal in opposition.
Okay. Not today.
I'm appealing for the on
59, you are for the? High Court is party in this case. Okay. Where is your senior? Passover or not today? Next circuit. Yes. তাড়াতাড়ি করুন এই যে আছে সেটাকে একটা টেনে দিই Yes, item number 60. None appears on behalf of the parties. Let this matter appear before the next circuit. 61.
I'm for the respondent may Lordship. Pay for extension of time for filing a order.
Finding.
Appeal in opposition may Lordship.
Who is for the petitioner?
Arul sir, Arul Prasad.
None appears on behalf of the petitioner. Respondent is represented by उनका नाम लिख लीजिए. He prays for extension of time for filing of affidavit of opposition.
Yes.
Opposition.
I'm appealing for the petitioner.
Oh, you are for the petitioner. Okay. He is seeking extension of time for filing of affidavit of opposition.
I think affidavit in opposition was filed by the official respondent.
Who is the official respondent?
1, 2, and 3.
You are representing whom?
I'm for the petitioner.
You are for the, he is for,
Already there. Sorry, Miller.
then
I have to file affidavit in reply. Or that time may be done.
the owner ये कहते हैं, then this option. Yes. Let this matter appear before the next circuit bench. Yes, who is in 62? None appears on behalf of the party. Let the matter appear over the line. Hmm.
I am appealing for the petitioner.
No, my feelings are appearing on behalf of the private customer, my lord. I pray that my lord, let this matter be fixed tomorrow, that she is engaged in court.
Not today.
There is possibly there is a direction upon the commission, file a report, I believe.
So let him come.
My lord, I may be permitted to see. the
Yeah,
report.
yeah, yeah. Not today, shall appear tomorrow. Yes, 64.
But let it go to next, sir, by, because there is a appeal is pending before the appellate authority,
Okay.
before the deputy commissioner. Whether they
On the prayer of learned advocate for the petitioner. Let
Not
this
on my
matter.
prayer. Not on my prayer. I am ready otherwise.
Okay.
The appeal is disposed of or not, I do not know.
So let it appear tomorrow.
Well,
Respondent may give sufficient information in this regard.
Right.
Not today. Mhm. Yes. 64. None appears on behalf of the parties. Let this matter appear before the next hearing. Parties are directed to remain present on the adjourned date. जितना है जिसमें पार्टी नहीं है उसमें एक डायरेक्शन देती है. Yes.
I am for the respondent.
Respondent.
I'm appealing for the
65.
Petitioner, they have to file appeal reply.
None appears on behalf of the petitioner. Learned advocate for the respondent prays for time to file affidavit in reply.
Not they have to file. Petitioner has to file already after.
You cannot make prayer on behalf of the others. You tell your matter.
The stage is fixed.
Learned advocate for respondent is present. Let this matter appear. इसको ऐसे लिखिए. None appears on behalf of the petitioner. No affidavit in reply is filed. Despite the extension of time to file affidavit. ছাড়ো কত দেওয়া দেখা ছেড়ে. None appears on behalf of the যে আগে দেখেছিলাম বলেছিলাম সেটাই কথা. অত দিলে আবার ওরা নেক্সট.
I'm appealing for the Additional issue. I think this matter may be fixed tomorrow.
On the prayer of learned advocate for the petitioner, let this matter appear tomorrow.
Okay.
Not today. Then day after tomorrow. On the prayer of learned advocate for the both side, let this matter appear on Friday. Yes. Hmm? Yes. Who is for the? Not today. Next circuit. Next circuit. Yes. Yes. Next circuit. Next circuit.
Seventy-one.
71 दाखव की 72. You are for the petitioner. Learned advocate for the petitioner. Short for time to file affidavit in reply. Let this matter appear before the next circuit bench. Petitioner is directed to file affidavit in reply in the meantime. Learned advocate for respondent is also present. Yes. Record them. None appears on behalf of the parties. Let this matter appear before the next circuit bench. Yes, 73.
NCR was conversation, I'm required to go through the NCR. Any case.
SGRSC. Direction আছে দেখি record give me record. Trial court report is necessary for hearing. Department is directly whether NCR has been received or not.
And you permitted to go through the NCR, you don't even start with the.
Next circuit. On the prayer of learned advocate for the petitioner, let this matter appear before the next circuit. Next circuit. Next circuit. Next circuit.
And prayer of the appellant.
No matter who prays.
Their matter.
No, here.
Am I audible, Your Lordship? Sound on नहीं किया system. कर दिया.
Yes, where is the,
Yes, Your Lordship.
where is the order of your court? This one. Yes,
Lordship, I've tried to send a copy of the order sheets. The last order records that this matter was dismissed on 18/11/2014.
when, what is the date of passing order?
18 November 2014.
Yes. Yes, dismissed for non-prosecution.
Yes. Absolutely right, Your Lordship.
And whether any step was taken for,
Lordship, I am the accused in that matter.
you are,
I am the accused in that matter. So,
who is for the,
in spite of the notice, the petitioner hasn't come here also.
you are for the respondent. State is a party.
Lordship, I was trying to indicate that complaint cases state normally nowadays does not appear. In any event, 10 years ago, the matter was dismissed for default. What remains?
You are a Hasmukh Mehta.
Yes, yes.
First, I am not here. State of with one.
But the state is a party. 138 per us.
138, Lordship.
Yes.
138 private complaint, state has no role subject to correction.
So you have challenged.
Lordship, I had filed a quashing in respect of the entire complaint. That was my challenge.
Already dismissed for non-prosecution.
Yes. I had filed in 2012. In 14, it was dismissed for non-prosecution.
Then
so nothing remains. Lordship may dismiss this matter as infructuous. Lordship may record is infructuous as the original complaint was dismissed for default. This order is before your Lordship.
Okay.
Obliged.
Learned advocate for the petitioner appears virtually and refer order of learned judicial magistrate first class dated 18th November 2014, whereby whereby CR 105 of 2009 initiated on the written on the complaint of Messrs. Arun Ship Engineering Works has already been dismissed for non-prosecution. The petitioner prays for the questioning of CR case number 105 of 2009 pending before the Landed Court of Judicial Magistrate, First Class 1 at Port Clear. But after passing the order of dismiss for non-prosecution, this application, this petition become infructuous. So he prays for dismissal of this. There is the application as it become infructuous. None appears on behalf of the respondents. Now, accordingly, this original of reason is dismissed. As infructuous. Accordingly, the original application along with connected application, if any, is disposed of. Interim order, if any.
No interest.
ऊपर दिए थे कि respondents are not disposed of.
Obliged.
Not.
After matter, it says 54.
Item number?
नहीं ये नहीं है ये तो
Three.
थोड़ा दूसरा है.
Yes, sir.
Very focus clear, my lord. Here, the suit was filed in 2019. Now, my lord, we
2019.
find at page 28, issues were framed on 22nd of March 2023.
Yes.
My lord, thereafter till date, the plaintiff has not examined any witness. There is an interim order also, whereby status co-directed
So
status
he is dragging.
dragging. Now, my lord, very
Yeah.
innocuous prayer, I have not served the plaintiff even, because my prayer is very innocuous.
23, page 23. Issue
28
frame.
is the, my lord, the issues were framed on 22nd March
28.
Page 28, my lord.
28.
Order dated 22nd March 2023.
Yes.
My lord, we find at the bottom, my lord, that order, whereby charges, the issues were framed. 22nd March 2020.
Record is taken up for framing officers. For determination of controversy with nobody. Issues are framed from the materials. Yes.
Thereafter, my lord, from last 4 or 5 days, the case is fixed for evidence. They are not bringing. Already there is an interim order, status order.
So what is their prayer?
My prayer is for their prayer, my lord. They
No.
are,
You are petitioner.
I am petitioner, I am defendant in this suit.
Oh. So your prayer for
For expedience.
Expeditious. Okay. Who is for the?
I have not served, my lord. I have not served, because my lord, if I go for service, this circuit will go. Very innocuous prayer, my lord, I have shown from the order itself, my lord.
Yes, take down. At the stage of motion, learned advocate for the petitioner submit that this issue, the tracking suit number 4 of 2019 is pending for evidence since 22nd of March 2023. But no witness has yet been. But no list of witnesses has yet been provided by the plaintiff till now. He prays for a direction for expeditious disposal. Where this matter is pending, which court?
My lord,
Civil Judge Senior Division.
Joint civil judge.
Okay.
My prayer, page 7, my lord.
Joint Civil Judge Senior Division. There is the order number 34. And I am convinced order number 34. The order number 34 NR submission संविधि. Accordingly, I am of the view that Civil Judge Senior Joint Civil Judge Senior Division take necessary step to dispose of this matter as early as possible, preferably within 6 months.
My lord, 6 months.
6 months, preferably within 6 months, and without granting unnecessary adjournment to the parties.
My lord.
The matter is disposed. Yes.
This has also been very enormous prayer. Your Lordship, what happened? These writ petitioners,
Yes.
there was a dispute with regard to the property in question. Now, one person has filed a civil suit against the predecessor in interest of the petitioner before the civil court, and that civil court, the civil suit ultimately ended in dismissal by this honorable.
Yes.
So in the meantime, what happened? Due to the decree passed in the civil suit, this property in question got mutated in the name of the person who filed the civil suit.
How?
Because
It
decree
was dismissed.
it was dismissed by this honorable. So trial court decreed it. Appellate court affirmed the
Okay,
decree.
yes,
So
yes.
during this period, they got it, the land mutated in their name.
Okay.
Now, after the order was passed by this honorable court dismissing the appeal, I filed an application for remutation of the name. And with great difficulty, after approaching this honorable court, they passed the order and mutated my name in the record of rights. Now comes the point of demarcation. I submitted for last 2 years, I have been submitting representation to the authorities, asking them to demarcate the land because under regulation 101, the authorities are responsible to demarcate the land. They have received the demarcation fees from me. Despite such fact, till today demarcation has not taken place. I can show the document whereby they have received demarcation fees from me after my application. Why they are not demarcating the land? Let them be directed within specified period of time to demarcate the land, my land.
Yes, sir.
Yes, my lord.
Why are you not demarketing?
My lord, they direct my lord to Sharon, my lord.
Okay. Very honest submission. Yeah,
3 months time.
3 months.
Then be 1 month.
They have to just go to the spot and show the boundary.
Let me advocate for the petitioner. Pending representation for demarcation. 2. Where your representation is pending?
Yes.
Where?
Tehsildar.
Tahsildar.
Yes, Tehsildar
To
Fararganj Tehsil.
Tahsildar Fararganj Tehsil. Since
Just a
when did,
yes, date and date. Just a
since
My lord may not record that I have said, my lord may just.
no.
Page,
Anything-
24th January 2022. My application is.
Sorry.
24th January 2022.
Since 24 January 2022. Sought direction upon, seeking direction upon the respondent authority to demarcate the land of petitioner as early as possible.
Demarcation fees
Let-
has also been paid.
Oh, those are not required to be mentioned. I will give direction as per law.
Yes.
If not paid, they will not proceed. Learned advocate for the respondent praise for and direction in this behalf. No.
Petitioner is seeking. them.
Seeking and
No, my lord, I think my lord inadvertently.
Not required.
Responded. My lord, person petitioner is.
the petitioner is seeking petitioner chapter.
I
is
am not
closed.
seeking any permission.
So-
Bound by your lord.
Okay. Then let me. Respondents are directed to entertain the representation of petitioner in accordance with law and do needful within 1 month or 2 months. 1 month,
If direct demarcation is there, Your Lordship.
Each-
Should presentation will.
if everything and yeah, proceed people and proceed and take necessary steps.
Respondent are directed to entertain the representation of the petitioner in accordance with law and who need to give it within 1 month.
Within 1 month. He is also directed to inform the outcome of the decision to the petitioner.
My lord, I have just now received instructions from the department. We are saying, my lord, the area, the word survey has to be used, my lord. Not the word.
As per
No,
law,
let him show
as per
that
law,
what
if
he-
you think that survey is required, then you may dispose of accordingly.
Sufficient.
Survey word
Oh.
will not be used here also because it is not there in the regulation. Let him show from the regulation that it is the word
Then
survey
we
is
file
used.
affidavit. my lord.
It is demarcation. Why you are saying, sir? Mandate नहीं है, representation hearing का है, वैसे भी mandate नहीं है.
No, my lord, but then in that case, my lord may dispose of the representation.
That's what all these order is.
No, you are at liberty to take decision.
My lord may then say dispose of the
You-
representation.
That is
in
what-
Yes,
accordance.
yes. Dispose of the representation accordingly. I am not directing you to
Demarcate the land.
demarcate the land at any cost.
No, my lord.
So I know a second time I have to
You-
come.
Yeah, you have to dispose of that yeah, representation of
My lord,
petitioner
no, then there is a.
and intimate the outcome.
Yes, sir. I it's still there now.
Accordingly, they will dispose of. Okay, regulation 101 बोले दो.
01, submission. Your Lordship, my submission may be recorded, Your Lordship, with regard to payment of demarcation. I have already made this.
And
My submission will be recorded.
prayer was made under regulation 101 and necessary demarcation fee has already been deposited.
Yeah.
ये दूसरा point और submission थी.
Right.
Thank you.
Five and seven. Lord, there are altogether 19 respondents. On the last week, my lord has passed an order whereby I have sheet short for time to serve upon the 19 respondents. And I have sent to them through speed post. But all the service.
SR not.
Not, my lord, but
Service
they are
is-
appearing for some of them, so that I can take the recourse with regard to the rest of them. Already I have taken the recourse.
Yes.
1457. 14.
Take down. Service against all the respondent has not yet been effected. Learned advocate for the petitioner prays for time to effect service against the remaining respondents.
My lord, their appearance may be recorded, they are appearing, so that.
4, 5, and 7, your lord.
Oh. Look respondent number 1,
5 and 7.
5 and 7 is represented by Yonar Namdita and you are
11, 13, 16 and 17.
11, 13, 16 and 17 represented by A. Rest of the respondents did not appear. Yeah. Both of you appear and file their Vakalatnama. Let the Vakalatnama filed on behalf of the respondent number 1457 and 11, 13, 16 and 17 be kept with the record. Let this matter appear before the next circuit bench. इवे क्या कथा होएगा चेक टू ओके अरेंज करके यस नेक्स्ट
And for the respondents.
यस
In this matter. The writ
who is
petition-
for the petitioner you are for the respondent
The writ petitioner has not included the forest department as the party respondent.
where is your affidavit in opposition
The surer was the appropriate authority will be the forest department. So the list of encroachers was forwarded to the revenue department from the divisional.
so it
forest
means
And
cost title is defective
it's posted because we kindly see this writ petition is earlier. filed
but for that
in that made the divisional forest officer as the party respondent to that case, but I don't know why.
for that presence of learned advocate for petitioner is necessary
They have not made the forest department as the party respondent.
not today matter will appear tomorrow item number 6 and 7
That's to say, because they are in forest, land or they.
will hear you in presence of the learned advocate for
The revenue department cannot file.
will appear tomorrow on
There is that, they're in forest land.
you are for the revenue department defective cost title so
And they have suppressed this very fact that this writ petitioner has earlier filed a writ application in that DFO party. This is the second set, it's the second writ application. Second round of litigation.
will pass effective order will pass effective order tomorrow
Fine.
Again, your question of
oh Nalendra Kumar Singh
This will take some time. Because we know.
yes yes
a lot of decisions have to be cited and.
now I do not have sufficient time in my hand so it is better to I am under pressure
Getting is also there, my.
yes
That is there.
then I will continue here will enjoy stay of at Port Blair on the consent
Next time I will bring.
okay good arrangement on the prayer of learned advocate for the petitioner let this matter appear before the next application yes
On the IOC, Indian Oil Corporation.
Jaipal appears for the petition, right? So morning, Silal sir had appeared in this matter.
no
So
the
let, I
Yeah.
will my.
Tulsi Lal Saab will
I thought-
represent Union of India and I was asking asking about the learned advocate for respondent number 2 and 3
And for IOC, also, Indian Oil
Okay.
Corporation, we have already filed our application.
so WPA should we proceed or defer
I need my reply.
reply
For
to
the petitioner.
reply to what
You were filed by the phone number 3,
when
Indian Alpha.
when
Extension of that. Long ago, we had prayed. So, they are the last chance.
affidavit time to file affidavit extended for 4 weeks August 17, 2023.
2 weeks.
Not yet filed. You are for the petitioner? Very well. Learned advocate for the petitioner prays for extension of time to file affidavit in reply as he unable to file affidavit of reply. Last extension was granted on August 17, 2023. But no affidavit in reply has yet been filed. However, for the ends of justice, his prayer is allowed. How much time you need to file? 2? For the ends of justice, the time is extended for 2 weeks to file affidavit in reply. Let this matter appear before the next.
I was appeared for the private respondent. This matter.
There is some problem here, Lordship.
Yes, tell me problem.
But initially I appeared for the private respondent, 4 and 5 in this matter. But now I cannot appear because I have been designated as junior counsel.
Union of India is there. And
Private respondents are there because Your Lordship, I am claiming promotion and seniority over the private respondent. So private respondents are very much necessary in this case.
no,
Initially, Mr. Rakesh Kumar used to appear for the private respondents. Now, after getting empaneled as a junior counsel, he says he can't appear for the private respondents. So he has to
I will
implement them.
intimate the client to engage counsel.
none appears on behalf of private respondents are not represented. Mr. Rakesh Kumar, who represented them earlier, is surrendered. Do you surrender your?
I have to give NOC to the.
He intimated them that he is unable to represent them as
Due to his empanelment as government.
due to his empanelment in the government panel. Let this matter appear before the next bench, next circuit bench. Mr. Rakesh Kumar, learned advocate, is directed to file the response of respondents submitted in respect of his intimation. Yes, appear before the next circuit.
Right.
His communication করতে হবে। Yes, call. Says. By the way, if both party appear in any other case. CRA? 44. Who is for other side? Oh, conviction, yes, yes. Yes. Other advocate may leave. Yes. What is the matter? You are challenging the order of conviction under section 10 of POXO Act. What is the ground of your challenge?
In this matter, the landed dismissal just relied on the inadmissible materials and unreliable pieces of evidence while convicting the petitioner appellant in the above case.
What are those inadmissible evidences as per you?
Can you see the page number? Page number 2, deposition.
Deposition of PW1 is victim card. Okay.
One.
Okay.